So next we will have our committee reports, and we will start with John Krawchenko with the Small Claims Task Force.
John, we can't hear you.
You must be watching the Masters.
Do you want to start with Nathan? I'll email John.
Yeah. Okay, Nathan, why don't you start, and
sure.
We'll hopefully get John's technical issues sorted out.
Well, hopefully my speech will be about as long as his technical issues, so not too long. The update on LIRN, we have had our first Library Information Resource Network committee meeting. We've populated the committee. That being said, if anybody has any interest in being on the committee, please contact me. I put my email available on the chat, so everybody has that contact information. We're always looking for more interested parties. The LIRN initiative over the summer has seen some movement. Their chair, Johan, has been very fantastic working with us. They hired Teresa Leach, L-E-I-T-C-H, in August, and she has been rapidly coming on board. As of last week, she had met with every librarian and tried to reach out to some of the executives throughout the province. So she has slowly been onboarding, or rather quickly, actually, I suppose, over all of September. We do know, and our biggest threat is something that Bill mentioned at the beginning, which is that there is likely to be a push for reduction in fees and therefore a reduction in funding for libraries and the system throughout the province. That is of concern for us, and we're monitoring that. We're working with the LIRN board to try to reach out to some of the benchers who are going to be the ones making those decisions. So I do encourage each and every one of you who has contact with or knowledge of any of the benchers to reach out to the benchers that you know and let them know the importance of libraries, the library system, and the county and district law president or county and district library system throughout the province, so that they understand that when they are making cuts or when they are making decisions about fees, that this is not something where there is very much fat. So please make sure that you reach out to those benchers and let them know. It is a political process. As we move ahead over the coming months, we expect that LIRN will be coming online more and more. They will be working to start drafting initiatives and moving the library system along to engage each and every one of you and each and every one of your libraries to try to make a more cohesive argument both to the Law Society and to gather data. Because one of the things that is very important is that many decisions, obviously the best decisions are made when they're founded in proper information, but we need to be able to get that information from the associations. So when those individuals, when Teresa and Johan, pardon me, reach out from LIRN, please make sure that you're engaging with them, and please make sure that if you have any questions, you reach out to me. The pandemic has shown that services can be provided virtually and have been provided virtually from most libraries, and that has been a fantastic thing throughout this pandemic to have those resources still available. That more or less completes my update. So, Bill, I'll leave it to you where we go from here.
Okay, John, are we fixed?
I hope so. Can you hear me now?
We can hear you now. That's
okay, great. I went and tried to find my Nathan Baker headset, so it's replaced the John Krawchenko one that wasn't working. Well, thank you very much for the opportunity to speak. I'm going to speak to you about the Small Claims Court Working Group. In the weeks that followed the suspension of operations in the Superior Court of Justice, the Small Claims Court Working Group was struck. Fola was approached to put forward a nominee from our executive to participate in this group. Our former second vice chair, the recently appointed Justice Kristen Wyszynski, took on this role, and I replaced her in October of this year. The committee is composed of 2 Superior Court justices, Justice Nukas and Justice Workington, with paralegal and lawyer representation, as well as representatives from MAG and court services. Since its creation, the working group has met 12 times and meets every few weeks via Zoom calls. The results of these meetings are concrete and tangible and can be found in the notices to the profession and public regarding small claims court. I would refer you to those practice directions, which are regularly and frequently updated. Just a quick note on that. One of the issues that I raised as part of the committee work was that much like people call Zoom fatigue, I was getting notice fatigue, and it was very hard to keep track of the notices. And just so you know, this working group is very, very much aware of that and is trying to make sure that as things roll out, people are not inundated with too many small changes, and trying to make them in blocks. Now, as you may know, prior to the pandemic, the workings of the small claims court, they were localized in your respective jurisdictions. Subsequent to the 16th of March 2020, the administration of the small claims court has been centralized in Toronto, which currently has a dedicated staff of 4 trial coordinators and 2 assistant trial coordinators. Requests for certain court services are routed through Toronto, and then they're assigned to deputy judges throughout Ontario who have joined the roster of judges willing to undertake remote work during this pandemic. Initially, the work that was being done in the courts was limited to urgent matters, but the list of services now offered has expanded significantly and will continue to expand as backlogs are cleared and everybody gains experience and confidence in the system. One of the main messages that the working group wanted me to pass on to you was that the small claims court is open for business. So deputy judges have received updated packages briefing them on new processes, and they have been supplied with SCJ email addresses and access to the OneDrive system. So I wanted to extend my thanks to the working group for allowing Fola to sit at that table and to take part in the process of reinventing the way work is done during this pandemic and perhaps even beyond. I also wanted to thank the members of the working group, but the centralized staff and the partners at MAG for their dedication and efforts in the working group. Back to you, Bill.
Okay, thank you. We've just discovered somehow that our agenda seemed to have missed a real estate report. And thankfully, we have both Merredith and Eldon with us today. And so if they would deliver their report, that would be terrific.
Sure. Eldon, are you still on the line? There you are.
I am.
Perfect.
Thanks, Bill. And yeah, that's obviously partly my fault for not paying close attention to the agenda until this morning. In any event, we're going to split this up and try and keep it to 6 minutes or less. As everybody who's been paying any attention knows, it's been a very, very busy 6 months in the real estate world since May. And I want to make 3 quick points. Number one is that the real estate bar, I think, has been very well served by the Fola Real Estate Committee. And by that, I mean by Merredith MacLennan, who has done a wonderful job getting updates out to people with the constantly changing situation and making sure lawyers have resources to go to. I'm happy to help out, but I want to give credit where credit is due. For those of you who are new, I just want to point out, Merredith and I work in a variety of different capacities to try and support the real estate bar. We work a lot of time with something called the Real Estate Action Committee, which is a group that works with the OBA to try and set an agenda for meetings with what's called the Real Estate Liaison Group, which the Law Society formed at our request some years ago. That committee has met on and off over the years to try and address different issues. We're now hoping that we'll be able to have that committee meet more frequently. I think that's where the process is going, and we're optimistic that we may be able to move some issues forward. And Merredith and I are both active with the Lawyers Working Group on Real Estate and Lawyers, which is an independent group which tries to address some of the same issues. So lots of different irons in the fire. Currently, you have a real estate report, which has all kinds of details. It has wonderful resources. If you're a real estate practitioner, please take a look at it. If you're a president and don't know anything about real estate, please give it to your real estate rep in your area. And Merredith and I may both repeat the message that we really need those reps, and we need those reps to be actively engaged and try and circulate information to the bar. It helps all of us if our colleagues are up to date on what is and isn't proper and what is going on. So we've been working on dealing with lenders. Lenders obviously are critical to real estate. We've now got a process where we can discharge mortgages thanks to some repeated door knocking. Everybody but TD Bank, who we hope will join shortly, pretty much everybody, will take your mortgage discharges by wire, which is a much better process with COVID. Wires have become much more common in real estate, and we've come across a big issue over $18. I'll just summarize it to say that lawyers are adding the $18 fee that their banks charge them to the amount required to close transactions, and it's causing all kinds of problems. We are working with the Law Society on the issue, and we're hoping that the Law Society will have guidance for the bar in best practices form in the next few weeks. That's what they've told us, and we asked, and they said, yes, you can tell the bar that there will be guidance coming. So please take a look at the update of June 26th from Fola, and it'll give you more information on that if you're looking for it. We're working on a couple things now and have got some real estate reps to volunteer for committees to look at the document registration agreement and the process for discharging mortgages in the province, both of which are important, both of which need updating, mortgage discharges in particular, because it's still dated 1992, which is a bit outdated. We're working with the Law Society on a review of the definition of lending client, which I won't go into detail on. If you're a real estate practitioner, you'll get that. If you're president, it won't mean anything, but we're working on that issue also. The last point I want to make is that one of the big events that's happened since May is the closure of all the land registry offices in Toronto. In the province. I want to make this crystal clear. It was not my fault. No matter what Jeff Lem says in his video presentation, which you have a link to outlining the new processes to be followed. So if you're not aware, there are new processes. You can still register registry documents, but you have to do it in the way that Mr. Lem has directed. Merredith, I'm going to stop now because I think I'm up to my 3 minutes and let you finish up on the highlights.
Thanks, Eldon. So there's just a couple of more things that we wanted to talk about. The next thing we were very actively involved in is virtual commissioning and remote signing. As you are all probably aware, virtual commissioning is here to stay. The legislation came in August that allows for virtual commissioning. It's not a temporary COVID measure anymore. It's a permanent. We've got lots of details on the requirements of the regulations permitting it, and links to a number of resources in our written report. All I'm going to say about it is the Law Society has an article on best practices for remote commissioning, and it says, and I'm quoting here, "It's important for lawyers and paralegals to note that there is nothing in the Act or its regulations that obliges a receiving party to accept a document that has been commissioned remotely." I think the same thing goes for documents that are being signed remotely. There's still a lot of debate back and forth around the real estate bar whether documents that are signed electronically or signed digitally are acceptable. And the bottom line is it's important to make sure you confirm with the receiving party, with the recipient, the intended recipient, that the manner in which you are having documents prepared and signed will be acceptable. We're also working on a couple of issues. We, in dealing with the transfer of funds that Eldon has already spoke about in terms of dealing with the banks and discharging mortgages and paying for wire transfer fees, we're also working very closely with Ray Leclerc from LawPro and the Canadian Bar Association, who are working with the Canadian Bankers Association and other parties on this. And so you'll see a link and a note in our written report that we're looking for specific details of wire transfer timing issues. There's still a lot of anecdotal stories of wires not being received in a timely manner, causing issues. So Ray Leclerc has agreed to receive and compile all of the specific details of it. Very quickly, We also work with, as Eldon mentioned, the working group on lawyers and real estate. One of the things we've done recently is prepared condominium documents for a resale transaction. They're useful resources for lawyers. They're useful resources for your clients. They're available for free on the working group website, which is lawyersworkinggroup.com. On that website, you're also going to see the latest version of the Ontario Standard closing documents, which I'll remind you, or if you're new, I will let you know, have been unanimously endorsed by Fola, by every single association in the province. Still aren't being used by all of the lawyers and all of the associations, but there's widespread use, and we'd like to continue encouraging the use of those. You can find those on the website. You can find access to the AREA standard form agreements. There's a suggested fee schedule. There's a mentoring initiative. There's so much more. Last thing I'm going to do is just reiterate something that Eldon said, which is we have been working very hard to get local real estate reps in every county and district for every association, so that when we share information, those reps can then disseminate the information to the real estate lawyers in their local association. It's been very, very helpful. And certainly during this COVID time, I think it's been critical. I think Fola was one of the leaders of providing real estate information or practical information for real estate lawyers. And without the reps to share that information along, it's not going to go anywhere. It's going to sit with Eldon and I. And so we encourage you, if you don't have a current real estate rep for your association, we encourage you to seek one out, to get one. We encourage you to ask your real estate reps to circulate the information to the real estate bar in your association. If we don't have a rep, by the way, then we send the information to the president, and we expect the president to be circulating it there too. So keep us updated. If your real estate rep changes, let us know. If you don't have one, please find one. If there's anything we can do, if there's anything you think we can do to help improve practice for real estate lawyers, don't be shy to send a note to Eldon, and he'll take care of it promptly for you. Thanks.
Thank you, Merredith and Eldon. The next matter on our agenda is the Family Legal Services Provider Licensing Model submission. You had heard earlier from Treasurer Donnelly that this was one of the initiatives that is ongoing at the Law Society, and we will be making submissions. Sam Michel, our Family Law Committee Chair, has been working diligently on this, and I will now pass the microphone, I guess, virtual microphone, to Sam to take us through us.
Thank you, John. Good morning, everyone. Just one more comment in addition to what John said. I will actually be covering more than just the FLSP. It's essentially a year in review with respect to family law. For those who do not know me, my name is Sam Michel. I am the Family Law Committee Chair with Fola. The information that I'll be providing you this morning, it will be broken into 3 parts. Just as a housekeeping matter, I ask if you have any questions to please post them below in the chat, and I'm happy to answer any questions at the end of my report if possible. Just by way of intro, it's no surprise that many of us continues to hear that family law remains to be in a state of transition. It's evolving, specifically in post-COVID as well. And we've all, or some of you may have heard about the recent amendments that was made to the Divorce Act and the recent introduction of Bill 207 by the Attorney General that is moving Ontario Family Law Act, Forward Act, pardon me. And lastly, what may, or some of you may have indicated, the most controversial issue surrounding the Family Law Service Provider license or scope of practice. I'll just briefly touch on the Divorce Act. The amendments that was made to the Divorce Act under Bill C-78 was scheduled to come into effect on July the 1st of 2020, but due to COVID, it has been postponed. my understanding, it will come into effect hopefully March 1st, 2021. In essence, the amendments mainly deal with the use of a new terminology of decision-making and parenting time rather than the old terminology used, custody and access. It also addressed mobility issues and the definition of best interest of the children. That's in essence the Divorce Act. The recent involvement that we've had, Fola had, is with respect to Bill 207, Moving Ontario Family Law Forward Act, is that we were invited to make submissions, and we've done so early in the year on January the 15th, in response to the Attorney General's request for feedback on Bill C-78. I could indicate what we have in essence indicated is that they should largely incorporate incorporate what was under the Divorce Act into the into the Children's Law Reform Act in Ontario, in order to protect and provide guiding path with respect to families who are affected by separation. Also, subsequently, we were invited, and specifically October 13, I participated on behalf of Fola before the Standing Committee on Justice Policy, and we've made submissions. And in short, these submissions were as follow: that we've agreed that the proposed Moving Ontario Family Act help in providing continued effort and in making access to justice more accessible to Ontarians, that it simplifies the appeal process. Before, there was some uncertainties as with respect to the appeal. Now they simplified it, and it addressed the archaic language concerning the Children Law Reform Act. It also addresses some of the concern issue with respect to child support. It assists families, and that the proposed create fewer inconsistencies between the federal and the provincial law, and by adopting the same terminology across the board rather than using different terminology between the between federal and provincial legislation. The new terminology also is a welcome step, and it's certainly away from the adversarial approach that we've seen in the past few decades, and it's towards a child approach center rather than, frankly, what I put it is, I summarized it as parents in an Olympic. They wanted to see who would finish first on the podium, and it certainly promotes cooperative problem solving. The expansion of the best interest of the child test, what was proposed in the legislation, it provides the court, lawyers, and litigants essentially with a primary consideration and factors to be taken into account. So rather than, I don't want to say on a whim, but it provides a guiding path essentially, and makes things much easier. Also, Fola, subsequent to our submission to the committee on October the 13th, one of the MPPs posed a question, and unfortunately I wasn't aware of one of the articles that they posed a question on. I subsequently looked at the article, and I sent them an email, and I sent also the AG's office, I copied him on that email, is with respect to the child protection cases. Originally, what the AG's office has indicated is that they've made, again, the appeal process is that you're required a leave to appeal. What we propose is that any application that is made pursuant to the Child, Youth and Family Services Act should have the right to appeal straight to the Court of Appeal without a leave. And that was heard, and the AG's office has made the amendments to reflect that. Now, the amendments was made not just by Fola, by other stakeholders as well. I could indicate currently the Bill 207 is on a third reading. So it's going forward, and hopefully it could be implemented at the same time as, or come into effect at the same time as the Divorce Act next year. Now, I have saved the best for last, and it's to do with the FLSP. I'm sure there is no doubt that this has been an interesting topic. I could indicate that we've done, I've spoken to many lawyers from across the province, and I was quite pleased by the turnout and the lawyers that have taken time out of their busy day to participate and share their thoughts with me and share their thoughts with other members as well. I've also had discussions with many stakeholders across the province. I could indicate, for example, I've spoken to the Toronto Law Association, the Advocate Society, the Family Dispute Resolution of Ontario, OBA, Family Law Association, and many other stakeholders. And also we've conducted jointly, that's Fola, the Advocate Society, and the Toronto Law Association. There's a survey out there. Approximately this far, we have about 240 people completed the survey, and we're hoping for more participants. So I would, and obviously the more participants, the more data that we could capture, and it would be an integral part of our response with respect to the FLSP. Katie will be sending out an email tomorrow, and I'm going to be asking with a link, and I'm going to ask all the presidents if they could encourage their members. It's going to be going to the librarians, and asking the librarians to send it out. I would encourage every single president to let their members know of the survey, and if they could take 5 to 7 minutes of their busy time to complete it, it would be quite helpful. Now I'll just turn my attention to the FLSP, and in summary, what essentially I have this far. Again, this is a draft. I expect to complete my my complete response in the next week or so. Just to give you some background, and I hate to repeat this if some of you have heard this before. This is the genesis of this is started by then the Attorney General Yasser Naqvi. It's in relation to the some of the litigants of the idea, the perception that they were grossly underserved in Ontario, and it caused a great deal of spike in self-reps individuals that are before the courts. Jointly, the AG and the Law Society of Ontario in 2016 have asked Justice Brancalo to undertake a consultation that would see the possibility of expanding the legal services option for families of Ontario. And obviously they include the proposals of paralegals, amongst others, such as law students or law clerks. On December the 31st of 2016, after receiving submissions from various organizations, including Fola, the Brancalo report was released, and the report has made 21 recommendations. I'm not going to go into the recommendations. The report is lengthy. It's readily available on the internet through Fola's website. So if you want to have a browse of the recommendations, feel free to do so. So in response to the Brancalo report, the Law Society on December 1st, 2017, I believe, convocation, they've determined to create a specialized license for non-lawyers to provide services in the area of family law. In July of this year, fast forward 2 years, the Law Society has invited us, amongst many stakeholders, pardon me, across the province. They were invited to make submissions with respect to the FLSP. I could indicate that a lot of time was invested in this, and Fola is determined to put a response that captures the voices of all lawyers across the province. In essence, and in short, again, I want to emphasize that the report is not 100% completed. In essence, what we have this far is that the scope does not provide and or increase access to affordable, competent legal services. Simply put, allowing paralegals to expand their scope of practice to include family law without any empirical data, that on itself does not equate to affordable access to justice for Ontarians. There is the general impression that legal fees charged by paralegals to clients are lower than fees charged by lawyers for similar services. Fola has conducted a deeper analysis, and it showed that there were some doubts and uncertainties with respect to that, and whether it will make actually any significant cost difference at all. I could indicate, I've mentioned that we've, along with the Advocate Society and the Toronto Lawyers Association, a survey, and I don't want to be giving numbers, but I could tell that based on the survey this far, a lot of, there's about 33% of lawyers currently in Ontario that they charge less than $200 an hour this far, based on that survey. Furthermore, we looked at there's lack of empirical evidence which to gauge this issue. Lawyers, legal fees continue to be tracked provincially, nationally, but at the same time, there's nothing that been found with respect to paralegals that is regulated in the market. So there is that data that it's not readily available. A number of new initiatives being implemented that would assist individuals seeking counsel in family law matters. And this was actually recognized by our very own treasurer, Teresa Donnelly, and that was recently in October of last week. Oh, sorry, last week or the week before, my apologies, sometime in October. We've also indicated that the FLSP is, well, not indicated of the view for now, that the FLSP is a de facto family lawyer with about a quarter of the education and training. And there is certainly some concerns with respect to its implementation. We have concerns with respect to the scope of permissible activities, and there are essentially all areas of family law with a very few areas that is being excluded. Quite frankly, and I hate to put it this, it's everything but the kitchen sink. And in any event, having said all of this, we're proposing that the scope would be limited to certain areas. Despite the fact that we disagree, we're of the view that, or majority of the lawyers saying, we're of the view that if they're permitted to have or to practice, their scope of practice should only be with respect to uncontested divorces. The scope of practice should only include custody and access where no expert evidence is needed or required, very similar to what the LSO has proposed in their call for comments, and child support where only in relation to T4 employees. Once is someone self-employed or has shares in a corporation, et cetera, paralegals should not be dealing with this. And certainly we're saying the Change of Name Act. I could indicate it's further, are further considerations that I might include, such as, for example, first appearance courts or consent orders where paralegals could act as an agent. Again, it's not 100% there, but it's an idea and it's a thought that I have in mind and that I will consider in the next couple of days to be included in my final submissions. Otherwise, Fola could not support the other areas as suggested in the call for comments, such as spousal support, property issues, and we're asking that these plans should be outside the permissible scope. Also, my thinking of also raising, there's also complex evidentially issues that could fall from what we portray to be a within scope to out of scope issues. So one has to be careful. And family law lawyers, when you speak to them, they all say there's always some form of other areas of law that is within the issues that comes before the lawyers. So we want to make sure and careful if paralegals are given that scope of practice, it doesn't fall within, outside of that scope. Then, quite frankly, it would be unfair. It would be unjust to litigants now that they have to go from a paralegal to a lawyer. And the idea behind this is access to justice and affordability. I fail to see that. In any event, I'll continue on with respect to competency. This is a very difficult area. Essentially, what is proposed is creating a family law lawyer with 1/4 of the education. They're asked that from high school to 2 years of college diploma and on to becoming a paralegal, where a lawyer, we all know what we need to do to become a lawyer, and I won't get into that. Many of us has done it. With respect to also what we've looked at is there's the limited license legal technician program, and LLLT, that's based out of Washington. essentially, in another term, it's paralegals having practicing scope of practice falls to family law issues as well. And my understanding that this program has now become the program is sunset because it was not, for all intended purposes, didn't function as it had been projected. So, someone else tried it and it just didn't work. Also, I'll go back to the empirical evidence. This whole entire exercise is predicted on the assumption that FLSP will be less expensive than a lawyer. But then again, there is no evidence to support this. This is a great leap in logic between we need access to justice to FLSP will be the answer. Again, one of the other thoughts that we have is that if the FLSP should be rolled out, it should be done slowly and incrementally rather than let's grant them the following areas that falls within the scope of practice. We've made some recommendations. One of the recommendations, I have to be cautious of the time. One of the recommendations is the family law rules that should be revisited. Family law lawyers would tell you that some of the rules is it's not in the litigants or not in the best interest of the clients. Repetitive court appearances that if it's futile doesn't, it's just extra cost, extra burden, and it does not assist in resolving the matter. One of the other suggestions or recommendations that we are going to make recommendation that there should be an increased funding in Legal Aid Ontario. There has to be some expansion in the technology aspect of this to make it easier for Ontarians to have access to justice. Other initiatives such as the Law Society and the Attorney General's Office to consider supporting and providing some assistance in implementation of the Pro Bono Student Canada and the launch of Family Justice Center across Ontario. The expansion of the legal coaching and unbundling services by family law lawyers. And finally, the alternative dispute resolution. I think this should be the forefront of any initiative driven by the Law Society to promote this amongst the family law bar. It's imperative. I think we all, some of us who has keen on alternative dispute resolution know that this is one of the best ways in resolving and cost-effective matter to many litigants. This is in essence my short synopsis of my report and our involvement. If anyone has any questions, by all means, I'm happy to answer it. And Sheena, you can't answer any, you can't ask any questions.
I'm just happy to have heard your report, Sam. Thanks for letting me hear.
Thank you, Sheena.
We can chat after.
You're going to hear it in a couple of weeks anyway, so it won't make any difference.
It's great for us to hear about it. Thank you. And I appreciate all of the good work you've done, Sam. From our perspective, you took this seriously, and we really appreciate all the good work and heavy lifting you've done. So thanks very much.
Pleasure. Thank you. Any questions? Does anyone have any questions? Well, you're making my day much easier. All right. Now we're going to move on to the most important part, your 15-minute break. So we'll take a break for 15 minutes. It's 10:36. Should we say 10:50? Everybody should be back, please. Thank you.